technical issue which we're dealing with, resolving, ensuring that all the mics are connected to the system, and that the feed is going into the videotaping and videography and the live stream. So grateful if you could give us a few more.
Good job today, Nancy. You on top of it.
Indies, and in particular the Faculty of Law. You are all here to see a constitutional law debate on judicial appointments. Now, this particular debate will take place in the parliamentary style of debate, and I'll say a little bit more about that later on. And in keeping with the spirit of a parliamentary style debate, certain difficulties have caused us to be starting at the time we're now starting rather than the prompt time that we had indicated. So we have our apologies for that. My name is Jeffrey Foreman. I am the debate moderator, and I also serve as chair for today's events. I'd like to start off by welcoming our guests, which include our judges. They are Mr. Michael Hilton, Ms. Dorcas White, Ms. Annika Brown. Also with us are justices of the Court of Appeal, including the Honorable Mr. Justice Dennis Morrison, President of the Court of Appeal, and Ms. Hilary Phillips. We also welcome the attorneys at law who are here. Invitations, of course, went out to several sources inviting individuals to attend. And we, of course, welcome, last but, of course, not least, the students of the program, of the constitutional law program here at the faculty, and students who are in second and third year. Now, most of you should have a copy of the program. We'll be proceeding accordingly. And the first major item is a welcome. The welcome should have been delivered by the Dean of the Faculty, Dr. Leighton Jackson, and unfortunately, he won't be able to deliver that welcome himself, and therefore the next individual on the agenda, Ms. Tracy Robinson, who is the course director for constitutional law, will double up today and bring us both the welcome and other greetings. So please welcome Ms. Robinson.
Thank you very much, moderator. President of the Court of Appeal, Justice of Appeal Hilary Phillips, our distinguished judges today, and we're awaiting Senator Brigham, who is on his way from a vote in the Senate. Counsel present, I see Senior Counsel Richard Small and others, former members of the faculty, colleagues and students. I want to welcome you to today's debate on what is a topical issue, one of interest to us throughout the Caribbean. It's my pleasure to welcome you also to what is in effect our classroom. This is our classroom as we think about the substantive issues of constitutional law in a slightly different setting. And I'm welcoming everyone on behalf of the 8 teachers of constitutional law, which include at the Western Campus, Sharon Folks-Abrams, who is here, Jeffrey Foreman, who is at the chair's position, Dion Jackson-Miller, who I think will be here, Nigel Gale, who is here, Glenroy Murray, who I think will join us, and Annika Brown, who is part of the panel of judges today. It's our great pleasure to have a distinguished panel of judges, and it's my pleasure to introduce them to you. To begin with the Honorable Michael Hilton, OJ, QC, who is a graduate of this faculty from the class of 1974. In fact, forgive me if I'm not correct, but I believe both you and Ms. White were in the same graduating year at the University of the West Indies, the second year of graduates. The president who is here with us is actually from the first class. The faculty is 50 years in another 2 years. Mr. Hilton has been in practice since 1976, most of it in private practice at his own firm and also at Myers, Fletcher & Gordon. He served as Solicitor General between 2001 and 2007, and he must have been the first or one of the first Caribbean-trained lawyers to serve in that position as Solicitor General. During that period, he appeared before the Privy Council in many cases, which you know if you're a student in this faculty. The Savings Law Clause case of Watson and the Queen, Lambert Watson in 2004, the case which every student knows of Kurt Mollison in 2003, and the case which you dare not enter the examination room if you don't know well, which is the Independent Jamaica Council for Human Rights case. Even so, Mr. Hilton is better known as a litigator in complex commercial matters. He's been described as one of the best litigators in the Caribbean and Jamaica's star litigator. And I did a count of no less than 40 appearances before the Privy Council in reported cases. No doubt there are more which are unreported. In this regard, my unscientific guess is that this puts him in a tiny elite group of one of the best advocates we have seen. His cases go far back as 1990. The Privy Council case, which third-year students may meet in administration of trust and estates, involving the Marley estate, to the recent Paymaster case decided by the Privy Council. He's been the chair of the General Legal Council, a long-time tutor at Norman Manley Law School. He is revered for his didactic lawyering, his training up of excellent lawyers, wherever he goes, public sector or private, to be at the mercy of his red pen, and I have heard about it, as a young lawyer is one of the greatest gifts you could receive. In a region where we think that lawyers must chat plenty, or people who chat plenty should be lawyers, where we still associate lawyering with the verbose and the confounding, Hilton reminds us of the beauty of conveying complex ideas with care, clarity, simple, plain words, yet extraordinary sophistication. Thank you very much for being here, Mr. Hilton. Dorcas White is also joining us on the panel of judges. She is the senior tutor emerita at the Norman Manley Law School, both trained at the Faculty of Law and the law school, and also has trained thousands of lawyers, Caribbean lawyers, across the region. Welcome, Mr. Braham. To say that Miss White is a legend is self-evident to everyone who knows her. And for the students who are about to enter the Norman Manley Law School, you will begin to understand. A recent student of hers said to me that she has an overflowing fan club, which is made up of fans and fanatics. Needless to say, you can guess where that person fit. In the latter fanatics category, I think. It's fair to say that Miss White is not just now a legend, she's always been so. Both Miss White and Mr. Hilton were part of that early class, the second class graduating with first class honors, then a rare honor in the Faculty of Law. My students tell me that that is shade. I quickly learned of the legendary Montserratian. I am told, I'm not sure whether it's true, Miss White, with a big afro in the 1970s, who suffered no fools. And I remember explicitly didn't allow shorts in her class at Caville. I confess that I was the year below and managed to get away with shorts during most of my time, but one couldn't in Miss White's class. She spoke her mind, was of impeccable and remains of impeccable integrity, demands high standards, exemplifies them with a razor-sharp mind. In my days, and I believe this may have changed, you would have rather walked to the police station and surrender without counsel than go to her tutorial unprepared. Warning. Yet her remarkable generosity over 4 decades of teaching sets her apart. Teaching you, as one person told me,
She teaches you how to unlearn in order to learn. Today, she's strongly associated with her tenure at the law school, from which she retired in 2007, where she consistently and continues to help produce world-leading MOOTers. Some participated in the World Human Rights MOOT. A number are also members of our faculty now, some in the Jessup MOOT, and I think she was part of the training team that led to Norman Manley's team ranking second in the Jessup MOOT, a team which included our Judge Anna K. Brown. We shouldn't forget her distinguished career at the Faculty of Law, in which she produced outstanding work on Caribbean legal systems, and especially resonant scholarship on freedom of expression in the Leeward Islands. Thank you for joining us, Mr. Braham. I know you have come directly from the Senate. The senator came to the bar in the aftermath of Hurricane Gilbert in 1988. There's no member of that class who doesn't remind you that they didn't have the graduation they expected as a result. He spent over 2 decades at Livingston Alexander and is the principal at Braham Legal. He was Jamaica's Attorney General between 2011 and 2012, and from my record, he was the first Caribbean-trained lawyer to become the Attorney General of Jamaica. He appeared in important constitutional cases, such as the Dabdoo and Vaz case, the Holness and Williams case, which you're learning in constitutional law as we speak, and the Tomlinson and TVJ case, which the second-year students also study closely. Senator Braham, you may wish to have a word with Carrie Law, which in a Freudian slip added a pregnant I to the title of the Holness case, and it is referred to there as Holiness and Williams. Mr. Braham, Senator Braham is a trained mediator and a fellow of the Chartered Institute of Arbitrators, has been involved in commercial arbitration on telecommunications, construction, a whole range of issues. He's been in complex negotiations, for example, involving the investors in Jamaica, bauxite and aluminium. He's the chairman of the Urban Development Corporation and also a former tutor at Norman Manley Law School. And you may not know that probably today, sitting across from him in the Senate chamber, was his nephew, Damian Crawford. He is also a committed KC old boy, and I'm told prouder yet to come from Haddo in Westmoreland. And Mr. Braham, I had to find out where Haddo was. I come from Westmorelites as well, and within a few minutes I was being told that there were a family of Leslies in Haddo, that it was the place which one took the Royal Mail to go to Mount Pelier, to catch the diesel, to come to Kingston if you went to school in Kingston, a small community in the hills of Westmoreland. I am sure Haddo is as proud of you. Finally, Anna K. Brown, our fourth judge today, is an associate at Grant Stewart Phillips, and also a tutor at Mona Law in constitutional law. She's a recent graduate of both Mona Law and Norman Manley Law School, where she was on the principal's roll. She has a first degree from Macalester College in Minnesota. She did the back-breaking accelerated 2-year LLB degree at UWI, what we call the direct entry program, and we have a few direct entrants in the room. Throughout her student life, she has been engaged in a range of organizations pursuing social justice and jointly authored an article on the mentally ill, which won an award for human rights and also was published in West Indian Law Journal. She has the accomplishment of the highest ranking team from the Caribbean in the Jessup MOOT. I asked a colleague what she thought of Anna K, and she said to me, Anna K is bright but doesn't rest on her laurels. Anna K works hard, remains intellectually curious, and has, which many of us know, the courage of her convictions. I also want to recognize, in addition to or 4 judges today, the support which the 2 members, the 2 teams received from the Jamaica Association of Debating and Empowerment, JADE, and their officials, and to particularly thank the 2 debate masters that provided support who couldn't be here today, final year students Kimberly Brown and Simone Townsend, excellent students, folks who I have plenty regard for and thank enormously for your work. So in a few minutes, the students will be debating the motion. This House believes that an independent commission should be responsible for selecting judges in order to enhance the rule of law and the independence of the judiciary. All students, the front bench and the back benches who are close by, are first years in their 2nd semester of studying law. Today's debate is our classroom opened up, and in a few minutes you'll be sitting in the gallery of the Parliament of Barjam, which is a Commonwealth Caribbean country. We're sitting in what Professor Ralph Carnegie called the meeting place of government and law. Barjam is the Caribbean today, but it's also the Caribbean 40 years ago. Barjam is the sort of country which the late Professor Carnegie sought to make sense of when he took up the mantle as the region's first constitutional law teacher nearly 50 years ago. Cynical, Professor Carnegie said that we can't do without a constitution, even if we can prove that it is theoretically impossible to produce a good one. He says, since it's indispensable, though imperfect, we have to rely on experience and reasonableness and restraint in its administration and its effective working. In 1974, 4 years after the inception of this faculty, just immediately after Mr. Hilton and Ms. White would have completed their exams, the then Barbados Prime Minister, Errol Barrow, introduced with success constitutional reforms which led to every single High Court and Court of Appeal judge being appointed on the advice of the Prime Minister. That very year, Sir Hugh Woodin, as chair of the post-Black Power Revolt Constitutional Commission, sent Trinidad and Tobago in an entirely different direction, proposing that there be a substantial reduction in the area of patronage at the disposal of the Prime Minister. And in 1976, the Republican Constitution, accepting the recommendations which the Commission offered, provided that the President of Trinidad and Tobago should appoint the Chief Justice after consultation, rather than on advice of the Prime Minister, but also the Leader of the Opposition. 2 entirely different directions. Barjam is also the Caribbean that Sir Fred Phillips, Francis Alexis, Sir Henry Ford, Lloyd Barnett, and my colleagues who are joining us from University of the Bahamas through the streaming, Ruby Nottage, who sat on the Bahamas constitutional process recently, that they met a Caribbean through their work through constitutional reform that was constantly thinking about strengthening judicial independence, which has led us to this excruciatingly imperfect reform in Ghana that requires both the President and the Leader of the Opposition to agree on the appointment of the Chief Justice and Chancellor. We know that there's never been any permanent appointment to those positions since the reform. Barjam, finally, is the Caribbean today. It is right now where we are in the Caribbean, marred by debates about the process of appointing judges. In Trinidad and Tobago, in the Bahamas, that's tuning in at University of the Bahamas. In Jamaica, at various points in Barbados, the OECS, and also in Guyana. If you're wondering if Barjam is a place where this motion matters, where this motion is worth debating, whether the argumentation
of the rules which will govern how the proceedings develop. So there are 2 sides, the side of government and the side of opposition. The government side sits to the right of the speaker, the opposition to the left. The government has to support the motion, which Ms. Robinson read out for us, and the opposition, of course, will oppose it. The debate will start with the Prime Minister, and then the leader of the opposition will speak, and the speakers will alternate until we come to the end. Now, the rules of each side of the debate is set out in the booklet, and for your benefit, I'll just read them out. So the Prime Minister will be responsible for setting up the debate, providing background to the motion, defines contentious terminology, identifies problems, and provides a policy solution. You will then hear the leader of the opposition set the tone for that side of the House and will respond to the Prime Minister's arguments. The Deputy Prime Minister will then develop the case of the government some more and rebut any arguments that have been raised by the leader of the opposition. Then the Deputy Leader of the opposition will further develop the opposition's motion and continue the rebuttal of the government. Then we move to the lower side of the House, where a government member will extend the motion by adding a new element to the debate with a different analysis, a different perspective. Then the member of the opposition will also provide a shift to the opposition's handling of the debate. And then finally, the government whip will, in his own way, show that the government has won the debate, usually by summarizing the various points, and the opposition whip will do the same thing for the opposition side. Now, having told you the rules and what is expected, members of the audience can also sit in judgment of the judges to see if they have come up with the optimal answer to what we've asked them to do. Now, each member of the House will have 7 minutes for their debate, for their presentation. During that period of time, they will be exposed to and expected to accept at least 1 or 2 points of information from the opposing side. Now, they'll be protected, so in the first minutes of their presentation, they cannot be disturbed by any points of information, and the same will apply in the last minute. That is to say, they won't be able to, the opposite side will not be able to ask them any questions. So those are the general terms of the debate. So when I leave this podium, I will go and sit in the speaker's chair and hopefully preside over an orderly debate. Now, the last thing I'd want to do before kicking things off is to introduce the members of each side, starting with the government. The administration is headed by Prime Minister Ruth Ann Roberts. Can you just, all right? She will be followed by Deputy Prime Minister Kimberly Blackwood, who will be followed by a member of the government, Jeff Simmons, I like the name Jeff, and the whip for the government is Jamaica Charles, who will, as I said, summarize. The opposition is led by Marvin Forbes. Marvin. He'll be followed by his deputy, Shamar Wedderburn. Then he will be followed by Delia Thomas, member of the opposition. And the whip for the opposition is Saeed Bernard. All right? So just please welcome, put them at ease a little bit. All right, so I think that's enough talk from this side of the room. We are now ready for the House to do the people's business, and I will position myself to kick things off. Madam Prime Minister.
over democracy is the rule of law, and that means we have to have an independent judiciary, judges who can make decisions independent of the political winds that are blowing. Judges, Speaker of the House, members of the opposition, members of government, ladies and gentlemen, a pleasant afternoon. This House stands to believe that an independent commission should be responsible for selecting judges in order to enhance the rule of law and the independence of the judiciary. The Constitution is the protector of our guardian citizens. Our Constitution has without a doubt implied a separation of powers doctrine and goes on to explicitly outline the duties of the legislature, executive, and judiciary. In an effort to ensure that each citizen has a right to a fair trial, our Constitution has even gone on to ensure that the nation has a Judicial Service Commission in order to uphold the independence of the judiciary. However, from the past and recent occurrences, the House has noticed the overlap within the responsibilities of each arm of government, and more specifically, the process in appointing our Chief Justice and judges. This overlap has only created a gateway to a political playground, thereby severely undermining the rule of law and the judicial independence. However, as renowned constitutional law lecturer at MonaMedia, Jamaica, Tracy Robinson has said, it is impossible to totally remove all political influence regarding the judiciary. It is thus the belief of this House that an independent commission, which is recognized as a tribunal free from unnecessary and external political influence, impartial in all its decisions, assured its existence, powers, and compositions are constitutionally entrenched. This House proposes that selected independent parties appoint 9 members comprised of eminent judges, lawyers, and citizens to form the independent committee as follows. The Chief Justice will be sitting on this commission. However, he will not be the head or have any significant influence or the ability to sway the decisions made within this commission declined. The ability to sway decisions made in this commission as follows. The Bar Association will be recommending 3 lawyers. The political ombudsman will be recommending 2 persons from civil society, and 1 JP will be sitting on this commission, and 1 human rights advocate decline. 1 human rights advocate from the Independent Bar Council of Human Rights, and 1 member from the Public Service Commission, who will serve as the chairperson of the commission, having the ability to vote and add to the decision making of the commission. However, he has no such duty of power to make any final decision within the commission, but oversee that an impartial process within the commission is carried out. This means that all decisions made by the commission will be decided by a vote. The members of the commission will hold tenure for a tenure of 3 years, and the Chief Justice holding post until 72 unless otherwise stated within the Constitution. Unlike Jamaica's procedure for appointing the Chief Justice on recommendation of the Prime Minister after consulting the opposition leader and the appointed Governor General, and be appointed by the Governor General, our commission will have the responsibility of selecting the Chief Justice. This will be done by widely advertising the vacancy of the post, which after applicants are narrowed down according to the required criteria, interviews and the background checks will be done to ensure that the best candidate for this job is chosen. This name will then be sent to the Governor General, who appoints the final applicant as Chief Justice accepted.
But Madam Prime Minister, I'm so aware that the Governor General is a part of the executive, and as a
yes, and according to my speech later on, that will be dealt with. Thank you. In assurance of independence, the Commission will be provided with a trust fund ingrained in the Constitution that will be used to the discretion of the Commission needed resources and other operational use, as well as the salaries of its members will be also entrenched. We acknowledge in order for this law to be in effect, we must follow proper protocol in amending the suitable sections within the Constitution that are deeply entrenched. Once this is done, this new law will take effect after the tenure of that current Chief Justice. In implementing this commission, the government aims to bring political influence over the judiciary to an absolute minimum. The core idea in this Caribbean constitutional law that is associated with the rule of law by definition is that of constraining state action ensures state accountability, that those exercising public power should do so lawfully and in accordance with the Constitution. Judicial independence demands that judges ultimately listen to their own judgments and make up their own mind as they have sworn a solemn oath to their country to administer justice fairly and impartially. Safeguards such as security of tenure and financial security will be put in place to protect this independence. Institutional independence is also necessary. It is important that the judiciary has control over the administrative matters that bear directly on the exercise of the judicial functions. It is extremely important who selects the judges that sit on the judiciary. L. Barrow said, the past Prime Minister of Barbados, who amended their constitution to allow the Prime Minister to appoint judges, believed that it shouldn't matter who selects the judges that sit on the judiciary, and that it really has no influence on the execution of their duties. But it does, according to the persuasive Canadian case, Valenti v. Impartiality refers to a state of mind or an attitude of tribunal in relation to the issues or the parties in a particular case. Judicial independence connotes not merely a state of mind attitude and the actual exercise of judicial functions, but a status or relationship to others, particularly to the executive branch, that rests on objective conditions or guarantees. A judge may possess the personal attributes of impartiality and yet still belong to the judiciary that is not independent. Likewise, the judiciary may be independent, but individual judges may nevertheless lack impartiality necessary to adjudicate fairly in a particular case. Yes, we have a...
Prime Minister?
Yes. Right, yes. It is a fundamental right for citizens to be heard by the impartial and independent body. This House believes that our proposal and mechanism used in selecting and appointing the Chief Justice and judges will ensure that the government of this nation will respect, endorse, and sustain the rule of law and appreciate the importance of separation of powers.
Thank you, Prime Minister.
Thank you.
Madam Prime Minister, panel of adjudicators, Mr. Speaker, Madam Prime Minister, I must first mention a misconception that you have profited to us today. The current Chief Justice in the Constitution is protected through entrenchment. But what you have proposed have no entrenchment mechanisms for the Chief Justice. That is injustice to the Chief Justice. We, the opposition, do not believe that the Independent Commission should be responsible for selecting judges in order to enhance the rule of law and the independence of the judiciary. This already exists. It is prudent for me, firstly, to define key terms: judicial independence, rule of law, independent commission. The Bangalore Principle of Judicial Conduct 2002 defines judicial independence as a foundation of the rule of law and a fundamental guarantee for fair trial, exemplified in its individual and institutional aspects. Not at this time. That simply means that the two branches of government should not operate or should not influence the judiciary. So the judiciary should act without fear or favor of the two branches. The rule of law, as defined by the United Nations Secretary General, is a principle of governance in which all persons, institutions, and entities in which sorry, a little nervous, are accountable to laws that are publicly promulgated, equally enforced and independently adjudicated. An independent commission is a commission or body that is distinct in others of the two branches based on the separation of power doctrines.
Point of information.
Accepted.
The government has clearly defined independence as independence from political influence, not any governmental branch.
Noted, but interestingly, by the definition of independence, it's also independent from everything. Okay. The concept of judicial independence evolved from the Act of Parliament in 1701. That simply is the development of this independence concept came from the hold of despotic kings on the judiciary. Sir Edward Coke, yes, the person who defined murder, in and of himself, was an example of what this kingship hold was like.
Point of information.
He was locked up because the King James I could not control him. He was too rebellious. The opposition policy is as follows. We believe that the current system exists, is effective and efficient. We believe in strengthening the country's resources while in developing this our current system. Interestingly, the appointments, tenure, and removal of judges' principles. This is a 2015
Point of information.
This is a 2015 practice. Sorry. I'm just nervous. Now, this was a 2015 study that was done. And from 48 countries of 58 countries in our Commonwealth system, they looked at the independence of the judiciary. Now, interestingly, we are positive that since this so-called selection of the Chief Justice is considered to be not inclusive of the entire selection process.
Point of information.
We not accepted. We are suggesting that 5 nominees from the Judicial Services Commission and 5 other nominees from the Jamaica Bar Association, whose mission it is to strengthen and maintain the rule of law and human rights. The Prime Minister will then select 1 member or 1 nominee from that group of nominees, and the Governor General would appoint in accordance to our Constitution. Interestingly, Jamaica is in fact with the rest of the world in terms of its development of this independent. Pardon? Barjam, sorry. Barjam is, in fact, 81.3% of the independent Commonwealth jurisdictions have kept their Judicial Services Commission from their independence till now. Obviously, government, there must be some merit in this.
Yes. Here.
But the $1 million question is, are judges accountable? Yes, they are. The Constitution profits that judges are accountable in terms of the rule of law and the Constitution. The separation of power contemplates that the judiciary will hold its members accountable to the law and to litigants through the process of appellate review. Just wrapping up, yes. guaranteed by Section 103 and 110 of the Constitution. Judges are accountable by way of removal from office for serious misbehavior and inability to fulfill their responsibility in their office. The Levers case in Cayman and last sentence. The Levers case in Cayman and the Gibraltar's Schofield case, where the Chief Justice was removed, exemplifies this point. That is why we are suggesting this. We will support it.
Gallery has to be this.
Members of the opposition, we have already highlighted that we cannot and we won't remove all the power from the executive. But Kate Mallison stated that while it is possible for the head of state to appoint judges and to have his influence still not affect the non-impartiality of the judiciary based on the fact that the head of state would appoint and not select. Mr. Speaker, distinguished members of the adjudicating panel, all especially invited guests, delegates of government and of side opposition, ladies and gentlemen of the audience, good afternoon to you all. The foundation has been laid by the Prime Minister, and as Deputy Prime Minister, mine is the task to further build on what my Prime Minister has started by further examining how the judiciary, being perhaps the most susceptible branch of government, requires the most caution in the selection processes, later identifying key authorities which have proposed an independent commission and why they chose to do so, and subsequently reiterating the Prime Minister's argument of how important it is to ensure that our judge selection processes is free from influence, thus concretizing our stance as to why we believe that an independent commission should be responsible for selecting judges in order to enhance the rule of law and the independence of the judiciary. Procedural fairness. Trial by an independent and impartial tribunal. The ability to decide without interference from the executive and the legislature, and no man being above the law. These are fundamental principles associated with the rule of law. With that said, ladies and gentlemen, what the government is putting before this House is that in order to enhance these principles, we need an independent commission to select judges. The opposition may ask why. Why can't we go by what was said by former Barbadian Prime Minister Errol Barrow, and then later conjunctified by the leader of the Grenadian Democratic Labour Party, Dr. Francis Alexis, who said that it is the other elements of the independence of judiciary, such as the security of tenure, protection of salaries, non-termination of offices during period of incumbency, among others, which secure judicial independence rather than vesting the appointment processes. Let us examine why. The judiciary, not accepted at this time. The judiciary is the branch of government entrusted with the judicial or educating power of the state. The core of the judicial independence is the freedom of officers to perform their judicial functions on the basis of the facts before them, in accordance with the law and without undue outside interference, threats, inducement, or pressure. While it is true that there are elements such as security of tenure, protection of salaries, and others, in allowing for judicial independence to an extent, unfortunately, there is a correlation between parties and politics and the operation of various branches of government, which may affect the principles of rule of law when analyzing the core functions of the judiciary, as mentioned by Kate Mallison, who is an academic professor at Queen Mary University of London.
On that point,
not accessible at this time. The judiciary has a responsibility to the public. A part of this responsibility is to ensure full impartiality on the part of judges, thus resulting in public confidence in the administration of justice. It is important to note that according to Kate Madison, great damage will be done to the legal system if the selection of candidates is on the basis of party and political affiliation rather than skills and ability. Because what we do not want is democratic legitimacy to be tarnished, thus resulting in a form of politicization that reduces the quality of judges appointed and transforms the judges into politicians with wigs. Accepted.
Finally, after the blurring your speech, you never gave us an example of...
I am getting to it, Mr. Opposition Whip. Please sit down and relax and enjoy the presentation. A makeup which is balanced between members from different backgrounds and institutions ensures that the Commission is not subject to the control of any particular interest group and so has the best chance of resisting external pressure and maintaining a strong commitment to a system free from political patronage. This is what the government is proposing, ladies and gentlemen. A system which ensures impartiality, a system which is free from the influence of party and politics, a system ensuring the good governance of the judiciary, and this is something that you cannot be opposed to. Currently, what obtains in most Caribbean countries, with the exception of countries such as the Bahamas and Belize, is that the Governor General appoints judges on either the advice of the Prime Minister in relation to the Chief Justice or on the advice of the Judicial Service Commission. Now, ladies and gentlemen, we cannot have a Judicial Service Commission that is comprised of a Chief Justice, President of the Court of Appeal, the Chairman of the Public Service Commission, 3 other members, one of which must hold or have held an office as judge, all recommended by the Prime Minister, and not worry about the absence of impartiality and the effects of parties and politics, and not be disgruntled at the idea that the executive branch of government has so much authority in the dealings and operation of the judicial branch of government, potentially jeopardizing the independence of the judiciary. Mr. Speaker, I put this example to you. Not accepted. Let us say, for example, I am an NCB scholar. While this may be true that they have paid the amount and it can't be refunded, I feel an obligation to NCB, and as a result, NCB says jump, I ask how high. Now, ladies and gentlemen, NCB is the executive. I am a member of the Judicial Service Commission. The Prime Minister has recommended me. I now feel as if I owe him. And as a result of my subjective nature as a human being, oftentimes even unknowingly, this skews my decision on the side I feel obligated to. And quite frankly, Mr. Speaker, this is something that we cannot have as a part of our judiciary. Why we have an independent commission, Mr. Speaker? Why should we? Because it works. And in this moment, it is the best way to enhance the rule of law and the independence of the judiciary. Justice Hugh Rawlings put forward the view that appointment should be made by the head of state acting in accordance with the advice of an independent body, wrapping up, an independence body, and the independence body should be broad-based and independent of government control. Cape Town principles on the role of independent commission and the selection and appointment of judges in the Commonwealth, last point, suggests that commissions should manifest independently, suitably composed and resourced, and that it should be set out in written form and published and widely advertised so all qualified candidates may apply, among others that my third speaker will elaborate on. Mr. Speaker, this is what we're vying for, independence. I thank you.
Tensions are rising in the house. Let's go with the vote.
Honorable House, you know, it's always a pleasure to compete against ones that have such exceptional arguments, backed by solid evidence, so much so you can hardly find a way through. However, Mr. Speaker, members of this honorable house, today is not one of those days. I could go on and on about the drivel that the government has laid before us today. Side government. I don't believe you're even listening to the policy implemented by the opposition. You come here purporting that you want it to be free from political interference, but yet you want the executive to appoint, and you have yet to prove why this independent commission works. We're going off on a tangent. Are you even listening to what your own arguments are? Who exactly are you going to make a point? You appointed the executive, Madam Deputy Prime Minister. You also, I wonder if you're aware that Judicial Service Commission currently not accepted already acts as a checks into these kinds of behaviors. No point did we say we're endorsing partisan politics. So we will have you calm down right there on that point. We reiterate that we strongly oppose the motion that this House believes that an independent commission should be responsible for selecting judges in order to enhance the rule of law and the independence of the judiciary. Mr. Speaker, the government will attempt to justify this backward move on the basis of giving independence. However, we believe that independence must be balanced with accountability. Therefore, we maintain the promotion of a policy where the appointment of judges is made by the head of state, acting in accordance with the advice of a Judicial Service Commission, and selection made from the list provided. Side government, you look perplexed. You should be. I'm wondering if you're aware of the motion not accepted. My role as the deputy opposition leader today will be to advance the argument, outlining further reasons for the aforementioned policy that my Prime Minister had outlined. And in so doing, I'll be paying keen attention to the following points. 1, the long history of the government's role in appointments. And 2, the ineptitude of solely having an independent commission. With that said, I go to my first substantive. Point is made in the case of Van Rooyen against the state, which comes from the Constitutional Court of South Africa, that the mere fact that the executive plays the role in the process is not, I repeat, not inconsistent with judicial independence. Side government, I know it may be challenging, but I urge you to keep this in mind. You may need to rethink what you have come up and said. The court purports that the executive can in fact retain the power not accepted to appoint judges without infringing on the fundamental independence required by the Constitution, so long as once they're appointed, judges enforce the law impartially and independently. Madam Deputy Prime Minister came and said we're endorsing partisan politics. Madam Deputy Prime Minister, I will have you calm down. This approach is followed by various other constitutional democracies. You know why? Because according to the Venice Commission report on judicial appointments, it is the international standard that commission should be accountable for its decision on what matters most, Mr. Speaker, is the extent to which the head of state is free in deciding on the appointment not accepted. It should be ensured that a role is given to the Service Commission and the head of state not be allowed to appoint that is not included on the list submitted. We're not endorsing the partisan politics, so please calm down. The opposition maintains the position that as long as the head of state is bound by a proposal by the commission, the appointment is not problematic. We are not endorsing partisan politics. Please calm down. The key, Mr. Speaker, the key is, as Elbar pronounced, is that once they're appointed, they must enjoy their security of tenure. Now, Mr. Speaker, allow me to take you on a journey to the case of Barbados to enlighten the government's darkness. Barbados had used the Regular Service Commission along with the executive. Then, in 1974, they went to the Prime Minister appointing judges. And then 5 years later, not accepted, they went to an independent, wanted to go to the independent commission. However, the 1979 Cox Commission recommended that the original provisions be restored instead. That is what the opposition is suggesting, appointment by the head of state, advising from the Service Commission. Accepted.
We're speaking of selection based on the independent, not the appointment. The appointment is already covered of selection by the independent commission.
Madam Deputy Prime Minister, I will soon deal with you. You cannot wait for your demise. I will come to you in a second, Madam Speaker. This, Mr. Speaker, is because the method is the one that ensures the most level of independence as well as accountability. Accountability to the public and accountability to the people's representatives. Mr. Speaker, the real question to be asked is why does the government want to skew the advance and to chase the Algerian? Furthermore, it is the one advised by the Commonwealth Latimer House Principles of 2004 that where no independent system already exists, appointments should be made by the Services Commission. Sir Alan Lewis stated that in our small economies, it is understandable why there's a certain overlap in the system, and the roles of the executive is to have interest in the state, and so we remain that they uphold this position.
Point of information.
No, Mr. Speaker, not accepted. The government has come and pronounced how widely accepted their independent commission, which they say is full of JPs and judges, but I will go on. It's how widely accepted. Please hold on, sir. How greatly desired it is, but what we see here is that the international standards as required, and the one that's used by nearly all the territories is the one that the opposition is suggesting. Side government, listen closely, because here is why I ask the sharp questions that you will creatively dodge. The article, Guarding the Guardians, Judicial Councils and Judicial Independence by Garope and Ginsburg, gives a very important point. They posit that the independent councils filled with these members that the government purported, JPs and all full of judges, do not by themselves guarantee the substantive outputs of independence and quality. This is because, not accepted, I wish they accepted, it's impossible to eliminate the people's representatives completely. Mr. Speaker, it begs the question, therefore, what exactly is the government trying to solve? What exactly will happen? Mr. Speaker, allow the opposition to give the members of the House the answer as stated by Garope and Ginsburg. If judges are disproportionately involved, they appoint their own successors. A case they describe as Tweedledee and Tweedledum. Mr. Speaker, they want to remove this political interference, but yet they come with these persons on their coming. But we'll get on to that. Wherefore, we emphasize the complexity of this role that the government and the simplistic view that importing this kind of measure is likely to have the impact that they desire on the quality of the judiciary. And we reject the view that the council should everywhere be consisted of those persons that they came with. Let us not be fooled, Mr. Speaker, by the notion in concluding of needing the government's measure to attain independence. What matters most is that there is a balance between accountability and independence, and that they are able to carry out their functions impartially and effectively. This is a big step in the wrong direction.
We, the government, fervently believe that selection by electing erodes the integrity of judges and the confidence citizens have in the judiciary. Distinguished Mr. Speaker, noble adjudicators, members of this honorable House, respected opponents, colleagues from the government, good afternoon. The motion before this House clearly states that an independent commission should be responsible for selecting judges in order to maintain the rule of law and the independence of the judiciary. The government strongly proposed this motion. Mr. Speaker, it is of paramount importance to highlight that the deputy opposition leader, as well as the opposition leader, has tried to convince you that this independent commission that we are proposing will not have security of tenures for these judges. However, if they were intrigued in the debate, they would have understood. Mr. Speaker, they fail to identify that the current commission that they are purporting weakens the confidence, the integrity, the impartiality of the judiciary.
Point of information.
Mr. Speaker, any description, analysis, assessment, or critique of judicial appointments requires the development and the deployment of a conceptual framework. Thus, this honorable House will have the benefit of understanding and appreciating the nature of such an independent commission in which we are currently engaged. It is also imperative to note that this independent commission will contain processes, resources, values, and outcomes. What are these processes I speak of? Mr. Speaker, recruitment and appointment of judges and judicial immunity. Let's look into resources, salaries, opposition bench, salaries and pension for judges. Remember me talking about values? Well, to begin with, there must be independence, impartiality, accountability, and efficiency, all of which will strengthen the outcome we anticipate. Members of the opposition, I saw you calculating. I hope you got the maths right, because the outcome is the public confidence in the judiciary.
On that point.
Mr. Speaker, it is of utmost importance to highlight that, based on what we are purporting, is that this will ensure that impartiality maintained within the justice system. Mr. Speaker, let me take a special look at South Africa and Canada Judicial Service Commission. Mr. Speaker, according to Chris Oxtoby, who is a senior researcher of the Democratic Governance Rights Unit, DGRU, he postulated that the current situation that South Africa has, it is one that is dissatisfactory in the judiciary's eyes. He also made mention that this vilified, denigrates, delegitimates, it's vulnerable of their freedom of expression and also to fair justice. Mr. Speaker, we as the government, in reaching this conclusion, we have been mindful of the principle of judicial accountability, whereas legislators, my opposition, may follow partisan agenda, but judges must follow the law. Mr. Speaker, in relation to Canada, according to an article titled Dirty Laundry, written by Richard Delvin, he made mention that the Parliament of Canada is solely responsible for the courts in relation to criminal matters and in organizing procedures. He further added that this weakens the integrity of the system. However, he made mention that they have went on experiment to improve their process of selection, but he said at this point in time, the failure is one that will see Canada having a long way to go in finding an applicable regime to appointment of judges. Mr. Speaker, old people would always say, take sleep and mark death. Opposition, this means that we should observe the outcome of current situation and use it to predict an event that hasn't yet occurred. Such analogy leads me to an article entitled Acting Appointment, Mark Disrespect, written by Justice Richard Lipton Robinson. Justice Lipton Robinson is a jurist who sits on the board in Netherlands of the ICJ Court, the International Justice Court. He made mention that, and I quote, the acting appointment of Justice Brian Sykes to sit as Chief Justice is one that is not in the interest of the country. It is not the best interest, and also not for the judiciary. He further added that this current system is where the Prime Minister is watching the appointee closely, and that anytime the government is disapproved of how the Chief Justice discharge his judicial and executive function, he will replace him at any point in time. Mr. Speaker, in fact, this actually takes away the power from the Constitution. In relation to specifically Chapter 7, which made mention, yes, I'm wrapping up, which made mention, which actually fixed the Chapter 7, which was inconsistent. Yes. So, judges, we urge public officials, members of the community, public leaders to work in an effort to draw people together to ensure, to educate them that such an independent commission is necessary before the rule of law is further eroded by the perception that justice is for sale and that justice in the public is undermined. Thank you.
Adjudicators, members of side government, ladies and gentlemen of the audience, good afternoon. No, a drowning man will clutch at a straw. This afternoon, the government is that drowning man. So since the government wants to play on the regular meaning of the word select versus appoint that you have yet to clarify, by the way, you actually haven't, but it's okay. So since you want to play on the subjectivity of the regular meaning of the word, let me point out to you that the Oxford Law Dictionary defines to appoint as the ability to select. Also, you have said that the Prime Minister should not have selecting power, right? You have said that. But then you go on to say that independent to you means independent from political affiliation and partisan politics. But in referring to the fact, not accepted at this time, but in referring to the fact that the Prime Minister ought not have selecting power, that is you directly referring to the executive and the relationship between the executive and the judiciary as being an issue of independence. So it seems to me that the government needs to clarify what meaning of independent you're working with. Your political meaning was inadequate, so I'm glad you brought up the executive so that we could actually deal with independence as it exists under the principles of constitutional law, since that is the broad heading under which we're debating. So welcome to the debate, side government. Now, I proceed to my first point. Interaction between the executive and the judiciary. Let me speak to the audience and the judges. Interaction between the executive and the judiciary does not automatically equal a breach of judicial independence. No, accepted. You said many things. You said many things. You have contradicted yourselves many times. Now, if you would listen, I would enlighten your darkness and help you to come to one argument, since you have proposed many different arguments. Now, according to the Bangalore Principles of 2002, under the section that deals with independence, a judge shall be free from inappropriate connections with and influenced by the executive and legislative branches of government. Note that it did not say that a judge must be free from all connections. It said that a judge must be free from inappropriate connections, and that directly implies that there are appropriate ways for the judiciary and the executive to interact. Accepted.
And we have already cleared the reason why the judge should not be appointed by anybody except for the commission. We have already stated what we meant by independence of the judiciary.
You stated many definitions for independence.
Independence of the judiciary. Independence.
At this point, your confusion is taking up my time. That is the end of your points of information. Note that it did not say that it must be free from all interactions. It said inappropriate interactions, and that directly implies that there are appropriate ways for them to interact, right? And we, the opposition, put forward that the appropriate way for the judiciary and the executive to interact exists in the way it does in our present system, where the Prime Minister has a say in who is ultimately appointed or selected, since you like to switch between the synonyms, as Chief Justice, and the Governor General has a say in who is ultimately appointed or selected for the purposes of our government as regular judges in our system. Now, if it was that the executive was to be found to be interfering in the operations of the judiciary, in the trying of their cases, and what rulings are being made, then of course that would be a clear breach of the independence of the judiciary. But the executive's involvement in the selection process or appointment process for the purposes of our government, the executive's involvement in the selection process, especially if carried out in the way outlined in our not accepted, outlined in our counter policy, does not offend the rule of law. And therefore, we do not need an independent commission to appoint or select judges or the Chief Justice to enhance the rule of law, because the present system does not diminish the rule of law in any way, shape, or form. Now, according, you expressed some concerns, especially Ms. Deputy Prime Minister, that, okay, if it is that the executive has a say, then naturally human nature, they're going to feel like they have to act in accordance with the executive. But let me prove why they don't. According to the Latimer House principles, how to ensure an independent judiciary, not accepted. 1, arrangements for appropriate security of tenure and protection of levels of remuneration must be in place. We have that. It is outlined in the Constitution. It happens currently where security of tenure is something that judges are allowed to enjoy, and they are paid via the consolidated fund, so they do not have to depend on the executive for their resources, so the executive is not holding an axe over the heads of the judiciary. Number 2, not accepted. Adequate resources should be provided for the judicial system to operate effectively without any undue interference. We have that. Ladies and gentlemen, interaction between the executive and the judiciary should not compromise judicial independence. We have that. Ladies and gentlemen, not accepted. And the fact that it says interaction between the executive and the judiciary should not compromise judicial independence shows that the interaction can exist. But that interaction does not automatically equal a breach of judicial independence. My second point, the executive having a say in the selection or appointment for the purposes of our government process of judicial appointments is more of an advantage than a disadvantage. Why is this so? According to the Latimer House rules, sustaining public confidence in the judiciary is essential. How can we sustain public confidence when this independent commission that is accountable to nobody but itself is responsible for appointing judges? How do we sustain that ever so important public confidence, I ask you, side government? Not accepted. The executive is a body. The executive is a body that we can hold accountable for their actions by virtue of the fact that we elect them. Ladies and gentlemen. Gentlemen. And it was said by Sir Maurice King QC, one of Barbados' greatest legal minds, that PM selection or appointment, to paraphrase for the purposes of our government, is consistent with democracy, since appointments are in the hands of elected officials who have a mandate from the people and are accountable to the people. If anything, having the executive have a say in the appointment process works in favor of the rule of law, as the executive is elected and given power by us. And since they are accountable to us, that process, the selection process, is forced to be transparent because they have to answer to us. And the government would like to say that, oh, this recent debacle, as you might put it, that happened with the appointment of the acting Chief Justice is clear indication that, oh, we need to, this is a clear example that the system does not work. But the fact that we as people were able to hold Prime Minister Holness accountable to his actions by virtue of the fact that we put him there is a clear sign that the way it works now is fine. It shows that the executive having a say where the people can be accountable to them is the way the system should work, because we were able to hold Mr. Holness accountable to his actions, and had an independent commission appointed, that Chief Justice, the acting Chief Justice, they would have been accountable to no one. I rest.
I'm getting Marshall the host.
Ladies and gentlemen, honorable judges, distinguished guests, a pleasant afternoon. It is my job here today before the Honorable Legislative of Barjam to show in very simple terms why the government side has won this debate, and I must say, it is a very easy job to do. Firstly, the opposition has been operating under some fallacious assumptions, which I will take the liberty of disabusing them of. There is a clear and easy distinction to be made, according to the Halsbury laws of England, between the words appointment, which is a more ceremonial and official role, and selection, which I would have assumed was well within the awareness of the opposition, given that they have been advocating for the Prime Minister to select and the Governor General to appoint. Furthermore, the government is not proposing that the word independent be an absolute notion. We recognize that we cannot be here investing absolute power into a commission who is selecting members to sit on our judiciary. Independence, as defined by the government, refers to independence from political influence, which is why we have taken the liberty of ensuring that a non-political figure, the Governor General, is responsible for appointment. The executive, as the opposition is clearly unaware, is divided into two sections: the dignified and the effective. The Governor General being the dignified, and the effective being the Prime Minister and his cabinet, who operate within the political arena. It is from the effective branch of the effective section of the executive branch that we have taken the power away. Our ingenious policy, if I do say so myself, requires that if the political part of the executive branch, not accepted, do not even, that the political part of the executive branch be stripped of their say within the appointment process of the judiciary, while still allowing them to retain the power of checking the power of the independent commission through the Governor General's appointment discretion. We, the government, have stood before this honorable legislature today and have tabled the motion that an independent commission should be responsible for selecting judges in order to enhance the rule of law and independence of the judiciary. The opposition has conceded that these aims are legitimate and reasonable, but that our commission but have argued that our commission will not achieve this, and we have said so. We have disagreed vehemently. The government has implied distinctions between formal judicial independence created by security of tenure and financial security and true judicial independence, which works in hand with impartiality. Simply put, institutional and personal independence of the judiciary. We looked at the case Valencian R, which said that, not accepted, which said that impartiality refers to the state of mind of a tribunal as well as the status of the relationship between other branches. We said that it is more than possible for a partial and biased judge to be a member of a seemingly independent judiciary, and true judicial independence is not achieved in such occurrences. This is what our commission remedies by facilitating the selection of judges based on merit. The Deputy Prime Minister raised the important point of quality assurance. As it stands, there are no expressed or enforced levels of qualification to be met when selecting a Chief Justice. That is to say, the Prime Minister selects out of his own discretion. And it is possible, not a certainty, but possible, that this Prime Minister might select someone so egregiously unworthy of such an office. It is that gaping hole that our commission seeks to fill. The government pointed out the flaws in the current Judicial Service Commission, saying that 1, the Chief Justice wields too much power over selecting, and which allows him to sway other members. And that 2, there were too many judges in the process, which could result in the selection not based on merits, but through cronyism. 3, the Prime Minister also wielded too much influence on the Judicial Service Commission through the 3 people which he is allowed to appoint to. The government accepted.
What are the examples of the judiciary behaving, appointing people without merit that you have to assert in this parliament?
As it stands, the Prime Minister is allowed to select a Chief Justice with a former leader of the opposition in St. Vincent, Mr. Vincent Beach, accused the judiciary and magistracy of being corrupt and dependent, as he complained that the judiciary here tends to give the benefit of the doubt to the government rather than what the law actually says.
Point of information.
Accepted.
Accused. That's the verb you use, right? Use the verb accused.
Not accepted. Furthermore, I am not here to debate vocabulary, Madam Member. I am here to debate a simple concept. He said, I have known one judge in St. Vincent who said that he could never rule against the government. It is this kind of partiality that we're trying to eradicate. Mr. Speaker, the government's arguments were not unfounded. Ladies and gentlemen, we look to authorities such as Justice Hugh Rawlins, who said that judicial appointments should be made by the Governor General on advice of an independent body, which is broad-based, to one, ensure that the process which we decide who settles disputes within our diverse citizenry considers a wide variety of views before deciding. Two, to bring to an absolute minimum the level of political influence impacting the judicial selection process. It is simply a fact that as it stands now, the status quo allows for the head of the executive to select a person who may potentially decide a case of whether or not he is to be impeached. That cannot stand, Mr. Speaker. I am here today in firm agreement with the motion that an independent commission should be responsible for the selection of judges to enhance the rule of law and ensure the independence of the judiciary. This House will stand on principle, or we will not stand at all. I thank you.
Thank you, Whip, and thank you for staying within your time limit. Opposition Whip, it is yours to close the debate.
Honorable adjudicators, Mr. Speaker, members of the audience, good afternoon. I would like to actually fulfill the role of the whip in giving the clashes in the debate and rebutting the very silly arguments portrayed by the government to this honorable House. Now, Mr. Speaker, the first clash that I saw in this debate was the idealistic compared to the practical, Mr. Speaker. Now, Barjam is a low economic society, and as a result of that, we don't have money to waste and put in an independent commission when we don't know who puts in place that independent commission. He spoke about being fair, being away, if you call me Reigns, being away from political bias. But at the end of the day, Mr. Speaker, who appoints this commission? As a matter of fact, if I may continue, if you're listening closely to yourselves, you'd realize that having judges on your panel of the independent commission is just a way of moving the interdependence, Mr. Speaker. As a matter of fact, if I may explain, if they may not be sucking up to the Prime Minister, but they may be sucking up to the Chief Justice. They may be sucking up to the person who is going to appoint the person below them. As a matter of fact, Mr. Speaker, not accepted. As a matter of fact, Mr. Speaker, it simply goes to show that the idealistic point of view from the government is that they will put the citizens, JPs. Oh, as a matter of fact, I thought JPs and citizens are politically aligned out of everybody in the society. Mr. Speaker, if you hold your reins, you've gotten your time to speak. Mr. Speaker, I do not know where this macaroni government is going with this policy. Mr. Speaker.
Order.
Mr. Speaker.
Order.
Mr. Speaker.
Order.
Mr. Speaker. Mr. Speaker. Mr. Speaker, if I may continue, I thought that the Prime Minister was macaroni, but then the whole bench is macaroni because their ideas are twirled and twisted as a macaroni. Mr. Speaker, if I may continue, the second clash in this debate was Operation. Okay, accepted.
The government has clearly said that the members of our independent commission will be selected by interest groups.
Thank you. And members of this specific interest group are also politically aligned. The problem that you're trying to fix is not being fixed because you're just being counterproductive. You remind me of the government that spends money, wastes money, and then come to this honorable house and said, we don't have any money. Mr. Speaker. The Prime Minister said that there will be no political affiliation. The Chief Justice will not have a vote or an influence of say. But Mr. Speaker, if the Chief Justice does not have an influence doesn't that sound like something like rubbish to you? Because the mere fact that he is the Chief Justice, people will be influenced by his decision. Mr. Speaker, the idealistic against the practical, Mr. Speaker. They are speaking about enhancing rule of law, but they need to understand that the difference here is that of operation to that of appointment. Mr. Speaker, what the government is saying is that there's be quiet. Mr. Speaker, what the government is saying is that there is bias in the operation of the judiciary. But we are saying, Mr. Speaker, that our system will ensure that we will ensure that it ends at the appointment. The only say that the Prime Minister has in the judiciary is the appointment. It ends right there. No, Mr. Speaker. Mr. Speaker, if you calm your nerves, Madam Government. Mr. Speaker, if you'll actually realize that this is the better way to go. No. Mr. Speaker, as it relates to the appointment, it is better for us to can see transparency in the appointment of our Chief Justices and our judges. Mr. Speaker, the motion says that an independent commission should be responsible for selecting judges. But the only thing that this government has talked about is that of Chief Justice. I am talking about judges on a whole. As a matter of fact, you have had the time. As a matter of fact, Mr. Speaker, Judicial Services Commission is a part of 4 commissions under the Chief Personnel Officer. And if the government had done their research to see who is under the umbrella, then they'd realize that the Judicial Services Commission ensures that there's a separation of powers as it relates to the appointment of and the discipline of people that are appointed. Mr. Speaker, if the Bar Association works as a disciplinary body for lawyers, if the Judicial Services Commission works as an appointment, a disciplinary, more so a separation inclination group, then why is it that we need to spend the money? And as a matter of fact, the government hasn't told us how much they will spend because it's in the qualms of their corruption. But Mr. Speaker, we grant to know that the legislation that we are putting forward will allow the people it will allow the people to see transparency. They will know who will be picked. They will be able to hold the Prime Minister accountable. But at the end of the day, Mr. Speaker, if an independent commission had put in place an active Chief Justice in the Commonwealth of Jamaica, then could we have held anybody accountable? Could the acting Chief Justice be easily or quickly moved to the Chief Justice? No, Mr. Speaker, because the Prime Minister is elected by the people. He is accountable to the people. And as a result of this, we strongly believe, Mr. Speaker, that he has the utmost right in selecting. As a matter of fact, he's not selecting on his own, not accepted. As a matter of fact, as to remedy the government's argument that he just chooses people without competence, we will remedy it for you. We give you a counter policy. This nomination list will ensure that people from the Bar Association and from the Judicial Services Commission give a nominees of 5 persons each. You know what this does? This ensures that there's competence. 1, that you clearly feel to lack. 2, this ensures that there's competence. This ensures that the person is ready and transparent and willing to do the work. Because, Mr. Speaker, these bodies are the disciplinary bodies that are in charge of the judiciary. And as a result of this, Mr. Speaker, in order to fix the problem that the government clearly has, then we will fix it, because their policy still does not ensure that competence is at the helm of our appointments. Mr. Speaker, last but certainly not least, I'd like to speak about independence. The government has wholly failed to give us a holistic understanding of what is independent. Independent in that sense means that there is no independence at all, because everyone in this room has a political affiliation by mind, by policy, or by which other means. Therefore, Mr. Speaker, I strongly hold that independence, the definition given by my opposition leader, is that of join yourself from the other arms of government. Mr. Speaker, the definition given by government as it relates to independence does not tell us the context of this debate. And as a result of this, Mr. Speaker, I would like the next time that the government actually comes to the faculty of law to do an actual constitutional debate and not to do a political fist water cooler talk on this topic. Mr. Speaker, last but not least, I'm wrapping up, Mr. Speaker, Mr. Speaker, last but not least, this House believes that an independent commission should not be responsible for the selecting judges, because the system is better that way. It enhances the rule of law and the independence of the judiciary. And the opposition wins this debate on the premises of our arguments, Mr. Speaker. I thank you.
All right, ladies and gentlemen, I think that brings us to the end of the debate. You can applaud both teams. Now at this stage, we will ask our judges to retire, to deliberate, and then return to us with their decision and any comments that they have on the motion as well. While the judges deliberate, what we like to do is to begin the discussion among the audience, and hopefully with the contribution of the debaters as well on the topic at hand. Give the judges an opportunity to reserve. All right, so we can do this in one of two ways. So we could open up the floor to any comments that audience members may have on the topic itself. No, not across the floor, stay where you know. But before that, I wanted to get some reactions from the debaters themselves in the process of preparing for the motion, and having fully now heard what the opposing sides said. Do you have any, I suppose, more dispassionate comments on the topic of whether, and when I say dispassionate, I mean not connected to the fact that you had to argue in favor of the motion on the voting side, and you had to argue against the motion on the opposition side. Is there merit in having an independent commission being responsible for selecting judges for the purpose of enhancing the rule of law and the independence of the judiciary? And I start off by sort of acknowledging that on the opposition side, you sort of conceded that some sort of commission should be in place in relation to the selection of judges. And I part of it was hoping that you would have. Well, that's part of the question. What is independence? Why should independence be there? Are we overhyping this notion of the selecting body being independent from what?
As students.
You're speaking as students, no?
Right. So as a student, we are told that the judiciary is in charge of ensuring that the other branches of government are held accountable according to what is said in the Constitution. And I believe it would be ridiculous to have an executive or members of the executive choose the persons who are going to be on the judiciary to ensure that the executive will be accountable to what is in the Constitution. I find it very ridiculous. So I believe it is that we should eliminate the power of the executive from selecting those that will be adjudicating the cases of behalf of them when they are infringing on the Constitution, and allow for an independent commission choose the judges, the Chief Justice, who will be in charge of making sure that us as civil society will have a fair impartial education, a fair process, in the fact that we can believe that the judges and the Chief Justice will ensure that their judgment is free from political agenda or free from political presumptions of anyone that might be on the executive.
What's of the argument then that so long as the judge has security of tenure, his salary is secure, his position can be dismissed, he can't be removed except for cause and to process in the Constitution, and all of those provisions enjoy a deep level of entrenchment in the Constitution. Why aren't all of those things sufficient to ensure that after being selected by let's say, a wholly political body, the judge is able to carry out his or her functions without having to look over their shoulder. That's it. Why a response to what you have said might be that so long as the judge has the benefits of security of tenure, which involve the executive not being able to disturb the salary and all of those wonderful things. Once they're in the post and have the benefit of all of those protections, they will be able to act impartially and independently of the person who appointed them, because they don't have to worry about being arbitrarily dismissed or being punished by the way of their salary, etc. being looked. Yes.
Alright, so in relation to that point, there's a microphone right there for you. Let them utilize that microphone.
Okay, so you are purporting that based on the fact that they have security of tenure, after it doesn't matter who selects, right? Right, that's what you're saying. But however, you fail to identify that in terms of the selection process is very essential. Why? Because this weakens the impartiality, the confidence and the integrity of the judiciary from the get-go of setting the rule of law, limiting the rule of law, and its true potential. So from the early start of things, it actually influences it. So that's the reason.
And that was according to you, Professor Law.
So you haven't quite told me why you're saying what the rule.
Okay, and this is me speaking as Delia and not as a member of the opposition. The debate is over and I have to stop. First of all, on the face of things, it is very easy to jump up and say, oh, of course we need an independent commission, like why is it even a question? Of course, on the face of things, especially in this current socio-political climate where we've all been jolted by the Prime Minister's appointment of an acting Chief Justice. But when it is that you actually do the research and you actually find that the scope of the executive's power in appointments is actually reined in, okay, that the scope of their power in appointment is actually reined in, that it's not just it's not just a matter of them acting willy-nilly, regardless of any rules, anything like that. There is actually a limit to where you can go, that the executive is not allowed to interfere in the operations of the judiciary. And when you look at the fact that our judges are protected by our constitution stands guard for our judges and their integrity in the fact that they have security of tenure and they are not paid through the executive, and the fact that when you then analyze the fact that the executive is accountable to us, and everywhere you look, when you're talking about rule of law, is to stay in public confidence. It is important for the executive to play some amount of a role, and that role is specifically within the appointment process. Anybody who wants to argue and say that the executive needs to have a role in the judicial process, me and them are going to have a problem on that front. That is problematic. There's going to be a problem on that front. But when we're talking about an appointment process where the executive has a say, and we're talking about the fact that even though the executive has a say in the appointments, they can't run the judge them in quote unquote. And then everyone wants to argue that, oh, we need a body free from political affiliation, as though in Jamaica there are so many people who are completely and totally free from political affiliation. That's idealistic, that's not reality, because most people have some sort of political affiliation, regardless of what how you hold that person in high esteem or whatever. Many people, how are you going to control the minds of people? How are you going to read the minds of people to ensure that they're acting free from political affiliation, if that's what you're trying to do? Marv, I understand that you have rebuttals, since apparently we're still arguing. All right, hold on, because Marvin did indicate to me when I started speaking that he wanted to have the mic. Mr. Speaker says Marvin has the mic.
when he spoke, mentioned an example of a judge feeling beholden to the government. He mentioned an example, I think it was St. Vincent, someone from St. Vincent, mentioning that a judge might feel beholden to side with the government when matters involving the state are in play. Is there a risk that if the executive has, let's say, a great influence in the process, that they may well appoint people who they think will, when confronted with cases involving the state or involving their specific political party, will just in the back of their heads always take a view that favors the state as opposed to the individual or a private entity in general. What's your view on that?
That's a very real concern, and it's a concern that acknowledges while we're doing our research, and that is why we proposed that the Bar Association of Jamaica and the Judicial Services Commission should nominate persons, should send up nominees, so that the government is not free to choose from a large pool of people where they can just choose somebody who will work in the favor of their political party, but they have set nominees that they have to choose from. We're not promoting an independent commission whatsoever, because the Judicial Services Commission is fundamentally not independent by virtue of the fact that it acts under the offices of the Services Commission, which is headed by the Chief Personnel Officer, who acts in the government, which is the executive.
No. Interestingly, when I began to do the research on this, I had one purview, but I realized that I thought that the so-called independent commission was a good thing initially when I started. But then, when I did my research, I realized that these countries, for example, South Africa and so on, that had this independent commission, if you really look on the totality of the circumstances, you will realize that the history of apartheid had something to do with the distrust of the judges that those people really had. And, hold on.
On South Africa point, what do you mean by that?
Meaning that because the South African they experienced apartheid during, up to the late 80s. It was not easy when they began to enter the democratic process.
But the process that they're taking for South Africa is that they do have a commission, but it's a commission that's dominated by politicians.
Yes, but what I was not there yet. I was going to talk about the evolution, but since you have gone on, I want to say that, interestingly, in my research as well, I realized something, that judges are really credible people, and there are few cases of the removal of judges from office, because the threshold is so high that the Privy Council has set. Like, for example, in Reeves and Crane, that's a case from 1994. You realize that if it is that in the process of trying to remove the judges, procedure is not properly followed by having actual judges from the jurisdiction or judges outside of the jurisdiction to investigate that particular matter, there'll be a breach. And so I want to say that although on the face that it seems as if there is an interference in terms of the executive function, but in reality, once the judge is appointed, like for example the Chief Justice is appointed, he has free reins. The only thing that he is accountable to is the people and the Constitution. So he has to follow, and he cannot breach. And of course, if there is a breach, you have appellate review and other things that is offered to the ordinary person.
There of course that question, how exactly is the judge accountable to the people?
Remember this, that a judge, all right, let me show you an example. The issue that occurred with Mr. Holness. I want to stay there. Now, because of what was, going around in terms of everybody commenting, including the natural population, right? The politician in and of itself had to resent. So, in other words, the judges in terms of dispelling justice as a whole, justice as a whole has to ensure that one, this dispelling of the justice is truly just. So and people know justice.
Hold on. When the judge has been appointed, you won't be able to. Sorry, we're going to open up to some comments from the audience as well. But I wanted to start getting full feedback from the debaters, because they for the last few weeks should have been reading to a lot of the material and these issues.
When the judges were here,
right. So the counterpoint I'm making, that I'm putting to you, is that the way we judges operate once they're in the position, protections that are given to them, they're not accountable to the popular will of the people, right? They are free to decide controversial cases in whatever way they want to decide it. So that if there's outrage by the population because of the way the decision was determined, that would be a basis to get rid of a judge.
No, that's understandable, and of course they have to follow the processes of the Judicial Services Commission or the other processes as outlined in. But what I'm trying to say, a judge is not immune to the cause of justice. Meaning, if it is, remember, at the end of the day, the law, in other words, at the end of the day, it's up to the discretion of the judge to balance the totality of what is presented before him in terms of the law and in terms of justice.
So it sounds like you would favor when the Barbados approach.
No.
Why not?
Because the Barbadian approach...
The Barbados approach, by the way, is where the Prime Minister effectively appoints the entire bench.
No, I'm not in agreement of that. Because I believe that based on the mandate of the Bar Association, I'm not getting into the debate, but based on the mandate of the Bar Association and based on the mandate of perhaps the Judicial Services Commission, this is the best approach. Not someone determining, oh, I will appoint you as a judge, based on his own personal criteria.
Why not? You said that the judge is accountable to the people and all these things. So once he's in the position...
No. I'm not in that. I believe in the separation of powers. I believe in the separation of powers.
And how does... Okay, this might run added to the circle, but there will be an argument that the executive, in the form of, say, the Prime Minister, playing a role in the selection of judges doesn't reach the separation of powers principle, because the Prime Minister, in so acting, is not directing the way a judge will carry out his role. Right? But I have to think about hand on one thing.
Good afternoon, everyone. It's interesting that I'm actually a researcher for the opposing side, because my view on an independent commission is a favorable one. Point being, through the program research, I have seen where this idea has merit. Throughout the debate, we spoke about particularly opposition, speaking to the reality versus the practical. I think it is important to point out that majority of laws were started as ideas, right? It's this notion that someone sees that there could be a greater accountability if we take this stance. And I think if we keep being backward in our approach to say that if there comes a time where we establish this commission, it will be overrun by persons with these ideas, these vendettas against persons. I think that we ought to think that everything starts with that idea, and we need to give the independent commission more thought before we actually say that, all right, be gone with this.
The opposition side seems to be in favor of the status quo, right? So we retain the existing system where we have a Judicial Services Commission that's headed by a Chief Justice, comprising the Court of Appeal President and others who must satisfy a certain qualification, right? Having done your own research and your personal view that that existing structure is inadequate.
To say it's inadequate, when you speak to the structure, with the composition of the persons that are on the performance of the judiciary.
It's the structure of the Judicial Services Commission as it now exists.
I think
so
all
for the purpose of ensuring the rule of law.
I think all structures in the judicial legal system as we have it in the common department, which do a great deal of work. So to say that this particular issue, I do believe it needs work.
What is wrong?
Well, I don't appreciate the fact that we have persons on this commission with a lower. There could be a long-term effect of vendettas plotting along the line, because we have persons with a security of tenure of 3 years appointing personnel that have security of tenure for a lifetime.
What's the problem?
So the problem that I'm having with the structure and composition.
You want the members of the commission, other than the Chief Justice and the Court of Appeal President, who have tenure based on their appointment as Chief and as President. They serve for a period of time, and then they have to come off the commission. Why do you want to give them more time?
That is always say I'm not promoting giving the persons on the commission more time. I'm promoting reworking the commission. What exactly? As was pointed out in the debate, the structure that we promoting. So it's still in line. We're still having independent commission. I think the government failed to highlight many points that I saw that could have come across. For instance, let it speak to why this is ineffective. And I personally, based on research, what would I implement to improve to have an independent commission? I think that's a tricky question, and I think it takes a lot of willpower and personal drive as a people to actually sit down and say, who are we exactly put on this commission? A gentleman from the audience while I was debating said, appointing an ethics board. But I think it comes back to who will comprise of this ethics board. So I think it's a lot of variables that I'm not at liberty to discuss right now as it relates to who exactly will make up those composition. But I think if we sit down as a people and get these perfect folks that we have here today to deliberate, I think we could do with an independent commission in Jamaica.
So existing commission is not independent in your view. Is that what you're saying? The existing commission is inadequate because it's not as independent as it should be. Alright, so this guy had a few comments and then I'll go to the audience.
Alright, so good afternoon everyone. I believe that one of the biggest problems that we have with the Judicial Service Commission in Jamaica right now, particularly, is the fact that you have a Chief Justice chairing, you have the Presidential Court of Appeal, the Public Service Commission, chairperson, and then another judge. And what the Constitution says is that the person who is somebody who has judicial influence. And what it says also is that it has to have 2 other persons who are not in active practice. And what we do not know some of the times, and based on my research, according to Kate Madison, is that some of the times these persons are not in active practice, but they have been in the legal work before. My problem with this is the fact that when you have too many judges or too many persons with so much experience, and that's why we were proposing the independent commission, in which you would have a broader base of persons, right? So the reason for this is because when you have too many judges, and every time it's an I know you, you know me basis. And especially in terms of not the puny judges per se, but particularly the higher court judges, especially in the nomination process. Not necessarily the selection process, but the nomination process. And this is according to Kate Madison, right? And it is this problem that we cannot have. And if we have such absence of impartiality in the selection, in the nomination, what's going to happen after? What's going to be the result after? What's going to be the fruit of the root? That's my problem.
I think we don't have some questions from this audience. Let's open it to some more. What are your thoughts on the motion?
So I have a few perspectives because I think the debate could have gone either way because I don't know that there's a strong argument for either side. Largely my perspective is that while an independent commission, if arranged properly, could add some level of value to the notion of judicial independence, in a practical sense it's not necessary. Because we don't have any evidence to suggest that the current system that we have now is stable in any particular way. The difficulty in removing judges already points us to the reality that judicial independence is secure. When we look at the security and payment provisions and the financial security provisions, there's no necessity there that an independent commission. And if we look into what it would cost to have an independent commission, we realize how necessary it is. So you have to be able to find that.
So are you telling us at the moment the existing commission is not independent? I'm sorry, when you say independent, you mean independent from what?
The one that was being proposed, not the current judicial service.
Oh no, I want to use on the current system.
Oh, the current system.
I'll leave the judges for the review.
Oh, well, I was thinking about that. But the current system has sufficient independence to carry out the functions before. Judicial independence is not an abstract thing. It exists within the confines of the Constitution. And I think it has been argued as this abstract, absolute thing. But if you look at what it is, they have sufficient independence. And it is a question of degree. And therefore, you have people on the commission who will be appointed. Yes, they're appointed by the executive, but they have security of tenure, they're there for about 3 years. They make their appointments, they deal with the removal of the judges, and then they move forward.
All right, so why, and I'll put it to the general audience if anybody has any other comments on it. But we all the comments so far seem to proceed on this notion that there's something horribly wrong with having politicians involved in the process of selecting judges. And I want to throw out there the idea that it might well be a good thing to have politicians more involved in the process of selecting judges. Because judges are not these people who are adjudicating matters in just black and white. Oftentimes they have to make certain policy decisions, whether when it comes to matters of interpretation of the Constitution, or even when it comes to matters of developing the common law. They all have their own views on matters, their own biases, their own preferences. And the true way to ensure that the law as it is developed by the courts
is in sync with what might be acceptable, palatable to the people on the whole, is to have politicians who have a better pulse of the desires, the aspirations of the people, to have a say in the selection process, as occurs in the United States, where in relation to the Supreme Court and the Federal Courts of Appeal, the President influences the philosophy of judges through the selection process. What's so horrible with that? All of these wonderful protections of security of tenure work. Why not have politicians more involved in the selection of judges? So the judges for the debate have returned. So I'll just leave my question hanging so that you all can think about it a little bit. So the judges, I don't know if you want to deal with the matter of the debate first, or if you want to give your comment on the debate and the motion, and then announce your, well, give your comments on individual debaters and the winners at the end. I don't know if you select that chairman among yourself.
Good evening, everybody. In particular, to the debaters, I'd like to say congratulations. We're very entertaining. We enjoyed enthusiasm about the MOOT and constitutional law generally. And we would say for us, there was one particular, it was very close, and that's why we spent such a long time. But we think that one particular team took the edge, and we would say that is the opposition. And we said it was the opposition for the reason that we think that they anchored their arguments a little bit more when they started off with the definitions. They used a lot of sources and there was more clarity. There's more else standard. But that doesn't say that the government did not equally well. As we said, it was close, and I think we need to some humility in that, to recognize that the work that you guys have put in, because we were impressed by all the preparedness of all of you. We do think the reason why we said that the opposition took the edge was the fact that they were a little bit more clearer than the government, and they were able to test your argument, and they had a good question in terms of who is the commission responsible to. I think that's something that you should think about. But aside from that, I think both sides were witty, very entertaining, and be encouraged and continue with this constitutional law and law generally. As for who we think is the best speaker, we are giving that to Daniel Thomas. We're very impressed by your wit, your clarity, your ability to outline your argument very well, and so feel good. As for the government, we think that the best speaker on the side of the government would be, I'm sorry, I'm going to do injustice to your name, but Jamaica, Charles, we thought you brought everything together very well for your members. We're able to take us through and give us a lot of clarity. And so you should also feel proud of your performance. And I think all of you should, so not because we're pointing out others, that doesn't mean that you didn't do very well. So that's basically what I have to say.
Thank you, judges, for your deliberation. We're not releasing you just yet. We also wanted to have your views, if you would provide, on the substantive motion. Should we have, is an independent commission necessary, but that's changing the motion. Should an independent commission be responsible for selecting judges in Jamaica, in the Caribbean as a whole? Do you have any views on the process that we have now? That it will serve the process of enhancing the rule of law and having independence of thought in the way the judges operate? Or should we seek to change the system in any way? And a question that I put to the audience before you came in was whether one change that we should contemplate should that be to increase the influence of the political branch in the selection process, since at the end of the day, the judge, after being selected, will not, the politicians will not have any influence over them in the form of salaries or removal, not to any great degree, etc. Your thoughts?
Let me go first. Thank you, everyone, and good afternoon, everyone. Thank you very much for making that meeting. I think that's a I think that the answer is definitely that there should be an independent commission in our view. I think that moving into the direction that Barbados did was a mistake. There's an answer that can be given to the need for an independent commission, which is that it is not the sole or only means of achieving judicial independence. That security of tenure is a very important factor, and various other factors are important. But the truth is that we need all of it. That the fact that there is security of tenure is not a reason to say that we need not be concerned about the way judges are appointed. I think that the Caribbean Court of Justice has gone to an extreme to protect the method by which judges are appointed, creating an independent body appointed by various public civil society groups, and I think that's a mark that we can all look at.
I'm attracted to the Barbados model, which is, yes, Jeffrey summarized the model very well at the end of his presentation while I was here. And the main reason why I'm attracted to it is that, one, I am not convinced that it necessarily follows that because you have a group of men and women that it guarantees independence. And I cannot speak to them as a citizen of Jamaica. However, I do have an opportunity to influence the politician. I can vote, and through civil society I may even influence them as well. And so after the judges are appointed, then of course they have to be protected. But I am not convinced that the system of services commission that we run in Jamaica is as valuable as we think.
In terms of my view, I think more of a hybrid between both my leads. For me, I think that there should be more independence in the commission. So the point that the government pointed out in terms of all of the people having the influence of the PM, for me, is very scary. And I think that there ought to be more balance and include other people as is included in the commission that is provided for in the Caribbean Court of Justice. But I also do understand that the Constitution was intentional for the involvement of RPN, and the opposition is also involved. Because we elect them, and we have to understand the role of the executive, and we elect them on the basis that we trust how they're going to organize our society and the choices that they are going to make. And so for me, I think we need a commission that's more balanced, that has more views so that we can select a person who is more balanced. Because the truth is, as the opposition said, that we all as humans are inherently subjective. But when we're able to have a set of people with different opinions, selecting somebody who's more balanced, we get to preserve the independence of the individual itself. It looks as if there's more independence with the judiciary and there's more appearance of independence, because it's important that not just that the system is independent, but that the people are confident in such independence. And I think allowing the involvement of the executive as well as some of these interest groups helps to provide that balance. And so for me, it's both.
Good afternoon, everybody.
Good afternoon.
We take a picture listening to 19-year-old teenagers debate on such a complex topic. Handling the sensitivity or authority by contemplating people. And after contemplating and also listening to annotate.
These are for the judges?
And so it indicated to you that the teachings is for younger and older.
Opposition side. So just any two of them? Yes. You just need to walk around the back.
And Senator Graham had reminded me that I thought to myself. So, you see, I'm so pleased and so proud. And what I can say is whatever system you get or any country gets, unless there's active cultivation of honesty, integrity, and trustworthiness in the society, we will always be debating about whether we should have 1, 2, or 3 groups of people electing people for office. Not that we shouldn't concern ourselves about that, but we should be concerned with cultivating in our schools, churches, everywhere, honesty, integrity, trustworthiness in human being. That H-I-T at the hit. And God bless us all. God bless you.
If I could just add one more subtle layer to the question regardless of the approach that you take, whether it's the politician directly deciding who should sit or commission without any political influence at all, should the process that is used to select judges be more transparent, in the sense of should some aspect of the process be open to the public viewing. For example, if you have an independent commission, should any interviews conducted by the commission to select judges be recorded and broadcast for the nation to see. If it is that politicians are going to be involved, should there be a hearing in Parliament that is open to the media? Of course, there's space for them to go. That is open to the media for them to broadcast it, so that the people see for themselves the persons who are both asking the questions, so that they can determine for themselves if these questions are appropriate, and to see the persons who have been considered for office. Should that be a part of the process, and would that help to enhance the rule of law and the independence of the judiciary, or more generally would be good for government?
So the latter part, yes, I think generally need that for government. But as for the process, I think it should be more transparent. I think we were attracted by the suggestion made by the opposition in terms of having the list of nominees being published. For me, I don't know the extent to which I would agree with it being broadcasted with the interviews, because I think there are certain things that should be private and that can possibly it may not help to bring more accountability. I think for me, knowing who the nominees are, knowing, having a public list of the criteria, I think is, for me, sufficient, but I have to think ponder more on the interviewing, the public advertisement of such.
And with regard to my own position, I wouldn't object to some form of parliamentary involvement and some publicity.
I think the answer to the first question you asked, Jeffrey, should there be greater transparency and relative good governance? The answer is absolutely yes, the board. Not sure that I would want to have a public interview in parliament kind of process, because I wonder whether that ends up politicizing in a way of people choosing sides because of all the reasons that happen. I think that the publicly advertising the positions, make it public, how many people apply, how many people are considered, those things will take us a far way towards the transparency that you mentioned.
Any comments from the audience or any questions that you might want to ask the judges? All right, it doesn't appear to be much more appetite, I assume, because people are now filled with the entertainment and knowledge that they expected to get out of today's proceedings. So what is left is for the debaters, the winners. Well, we start with the government, the runners-up. So this is a point where we give some tokens, some prizes to both sides, the winners and the second place, the runners-up. Yes, each other getting a small token. So, how we want to do this now? Yeah, so. Right, so you can snap on all of this. Mr. Weatherburn, who served as Deputy Opposition Leader, Mr. Bernard, and then Mr. Fox. Congratulations to you all. The backbenchers as well. Right, so the persons who did most of the research served as backbenchers in Parliament. So they are also getting tokens. Please congratulate them as well. They did their own work. Right. I know the government. So we'll do this part of the proceedings. Prime Minister. Okay. Alright, you shake it. There, your right, make it up here. You may have a more tangible view. Alright, so we also wanted to give some tokens of thanks to the judges as well. Where did Andrew? Sorry, one moment, please. Oh, okay, right. So the debaters will present the gifts. So each of you, the Hilton, the ladies first. That's okay.
Very good. Right on. Yes. Second lady. All right. And now gentlemen. All right, so I think we are now at the end of the proceedings. Thank you all for attending the debate, and we look forward to having a similar one next year. Who knows?